Get ready, start. The recent trend in government policies insinuates that despite the need for legislation does not seem apparent or sought by the targeted groups, the state acting under the paternalistic impression comes up with policies which are sometimes questioned by those groups themselves. In the long list of such legislative interventions, the latest entry is Uttar Pradesh Population Policy 2021-2030 and its counterpart, the Uttar Pradesh Population Control, Stabilization and Welfare Bill 2021. The government is appreciating its policy mechanism of incentivization as well as disincentivization for more than two abled children as the best measure for population control in India's most populous province. The fundamental objective behind devising this policy is to scale down the fertility rate in the concerned demography from existing 2.7 per thousand to 2.1 in the next 5 years and 1.9 by the end of this decade. However, the efficacy of state sponsored regulation of family planning is devoid of any evidentiary support, and thus such coercive measures need serious deliberation due to its uneven impact on various stakeholders owing to the socio-economic disparities prevailing therein. Since a lot has already been said and written on the implications of disincentivization over the lives of lower castes and minority religions who are treated as real breeders, subversing population balance. Reproductive autonomy entails the control of a woman over her own reproductive choices. It needs to be understood that the exercise of reproductive choices encapsulates the willingness to procreate as well as refrain from procreating within bracket Sucheta Srivastav versus Chandigarh administration. As a matter of law, the foundational basis for such a recognition is to respect the right to privacy, bodily integrity, and dignity of a woman. This implies that the exercise of reproductive choices are completely exclusive of any unwarranted interference, and thus a woman cannot be compelled to indulge in any sexual activity whatsoever upon her refusal. The recognition of reproductive choices as a constitutional entitlement can be traced to the case of K.S. Puttaswamy versus UOI, wherein the apex court recognized that the capacity to make reproductive choices form an inextricable part of personal liberty under Article 21 of the Constitution, and thus read the right to refrain from procreating into the right to bodily autonomy and privacy. The patriarchal social setup, however, runs parallel with this constitutional framework, as there are a myriad of extraneous factors which outrightly discount the reproductive autonomy of women in India. Population control policies, coupled with pervasive birth control methods such as abortion and sterilization, attain a sheer eugenic significance and thus operate as a regressive instrument against these cardinal virtues of dignity and bodily autonomy. Since abortions in India are state regulated, women in general do not have a right to abortion. The regulating statute Medical Termination of Pregnancy Act 1971, hereinafter MTPA, is largely centered around the discretion of medical professionals and allows for lawful termination of pregnancies only under certain specified circumstances. In the backdrop of MTPA, the population policy merits close examination to understand how it reeks of legislative biases against women and leads to discounting of their reproductive autonomy. Stop.